What determines whether a bill is a bill by popular initiative is whether the bill takes the shape, form, and follows the procedure under Article 257 of the Constitution. In addition, honourable members, looking at the bill under consideration by this House, the enacting formula clearly reads, and allow me to quote, "A bill for an act to amend the Constitution by popular initiative," close the quotes. And further quotes, "enacted by the people of Kenya." This further settles the fact that the bill before us is a bill to amend the Constitution by popular initiative and is to be enacted by the people of Kenya and not by Parliament. Indeed, it is also worth noting that the Joint Committee did also consider this question, and in paragraph 337 of its report, the committee found that the bill is one by popular initiative under Article 257. With these facts, honourable members, the bill before this House is therefore evidently one which is a bill to amend the Constitution by popular initiative in terms of Article 257. Honourable members, Article 257 clauses 5 and 6 of the Constitution provide for the submission to and consideration by county assemblies of a constitutional amendment bill proposed through popular initiative. The provisions state, and I quote, clause 5, "If the Independent Electoral Boundaries Commission is satisfied that the initiative meets the requirements of this article, the Commission shall submit the draft bill to each county assembly for consideration within 3 months after the date it was submitted by the Commission." Clause 6, "If a county assembly approves the draft bill within 3 months after the date it was submitted by the Commission, the Speaker of the County Assembly shall deliver a copy of the draft bill jointly to the Speakers of the 2 Houses of Parliament with a certificate that the County Assembly has approved it." Close the quotes. Honourable members, the Constitution expects county assemblies to consider and deliver to Parliament their decision on a draft bill within 3 months after receiving the bill from the IEBC. Records available in Parliament indicate that the IEBC submitted the draft bill to county assemblies between the 27th of January 2021 and the 2nd of February 2021. The Constitution requires county assemblies to consider the draft bill within 3 months after the date it is submitted by the Commission, and that the Speakers of the county assemblies shall deliver a copy of the draft bill to the Speakers of the 2 Houses of Parliament with a certificate that the county assembly has approved it in the case of an approval. Further, to be introduced in Parliament, a draft bill must be approved by a majority of the county assemblies, being 24 county assemblies. Honourable members, the question as to whether the threshold was met in the county assemblies relates to the reported passage of multiple versions of the bill. Indeed, the report of the committee has extensively tackled the matter of the errors. I would therefore not wish to overstate the matter any further, save to say that by way of communication from the chair issued between February and March 2021, I regularly updated the House on the progress of submissions of certificates of approval by county assemblies. From the last update of 4th of March 2021, the total number of county assemblies that had approved the draft Constitution of Kenya Amendment Bill 2021 was 42, whereas 2 had rejected the bill. Based on this fact, the House Business Committee scheduled the bill for introduction in the House, which was done on the 4th of March 2021. Honourable members, in construing whether the majority threshold was attained, the certificates and the accompanying bills were considered on their prima facie basis as the documents expected to be submitted by the county assemblies. Indeed, deriving the practice in law, Section 83 of the Evidence Act, Chapter 80 of the Laws of Kenya, states as follows with respect to certified documents. Section 83, certified documents, subsection 1. The court shall presume to be genuine every document purporting to be a certificate, certified copy, or other document which is A, declared by law to be admissible as evidence of any particular fact, B, substantially in the form and purporting to be executed in the manner directed by law in that behalf, and C, purporting to be duly certified by a public officer. Subsection 2, the court shall also presume that any officer by whom any such document purports to be signed or certified held when he signed it the official character which he claims in such document, close the quotes. Honour members, I'm not aware of any concern regarding the validity of the certificates received from the county assemblies. It is therefore evident that the draft bill obtained the constitutional threshold for passage in the county assemblies and is thus properly before the House. Honour members, a secondary issue did arise from the submission of the copies of the bills by the county assemblies with regard to the operative version of the bill in light of reported circulation of different versions and errors in the bill. On the issue of the errors noted during the joint consideration of the bill by the two committees of the Houses of Parliament, I agree with the committee's findings that although Parliament may, in exercise of legislative power under Article 94 of the Constitution, take steps to correct noted errors, this may pave way for new substantive insertions that may ultimately affect the form and substance of the bill. We may then run the risk of eventually overriding the principal intentions of the promoters of the bill and therefore offending the whole idea of an amendment of the Constitution by popular initiative. In any case, the errors have been observed to be inadvertent and mostly typographical or cross-referential, and that the text of the bill is sufficiently clear as to what it intends to amend. The errors were noted in clauses 13b, 48, 51a, and paragraph 1, subparagraph 1 of the second schedule. With the public debate that has raged on regarding this matter and the explanations given by the originators of the bill, any person interested in the matter surely understands the intention of the promoters, notwithstanding the errors. The House will therefore continue to consider the bill that was introduced and committed to the Justice and Legal Affairs Committee as submitted by the IEBC. Honour members, the second issue was on whether the provisions of the bill upset the basic structure of the Constitution and whether it contains unconstitutional constitutional amendments. I note that the committee has, at paragraphs 369 to 379 of its report, also exhaustively interrogated the constitutional propriety of the bill. As noted by the committee, the premise behind the basic structure theory that is said to preclude the making of certain amendments to a constitution is the centrality of the provisions targeted for amendment to the sovereign will of the people who give themselves a constitution for posterity. The theory is majorly derived from decisions made by the Supreme Court of India on amendments made to the Constitution by the Parliament of India. Honour members will appreciate that the constitutional history and the text of the Constitution of Kenya and that of India are markedly different. A key departure between the two constitutions is the manner in which they provide for their amendment. Whereas the Indian Constitution provides for amendment of the Constitution by Parliament only, the Constitution of Kenya provides for amendment by either parliamentary initiative or a popular initiative. Further, honour members, the Indian Constitution does not expressly protect any part of the Constitution from being amended. Conversely, Article 255 of the Constitution of Kenya outlines the additional requirement of submission of a bill for approval at the national referendum if the bill seeks to amend any of the matters listed in this article. Honour members, when comparing our jurisdiction with the United States, it is also notable that Article 5 of the United States Constitution provides as follows, and allow me to quote: "The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof, as one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. Close the quotes. From the foregoing, honorable members, it is notable that the U.S. Congress can propose amendments on its own motion or upon application by the legislatures of several states. It is also worth noting that the U.S. Constitution may also have what is termed as basic structure of the Constitution that may not be amended. Indeed, Article 5 of the U.S. Constitution provides that no amendment in any manner shall affect the first and fourth clauses in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. And I'm sure most members will appreciate that this is 2 members from each state. Honourable members, you will recall that the making of our Constitution benefited greatly from the Constitution of the Republic of South Africa. And in Section 74 of the Constitution of the Republic of South Africa provides the procedure for amending the Constitution as follows. Bills amending the Constitution. Section 74, subsection 1. Section 1 and this subsection may be amended by a bill passed by A, the National Assembly, with a supporting vote of at least 75% of its members. B, the National Council of Provinces, with a supporting vote of at least 6 provinces. Subsection 2. Chapter 2 may be amended by a bill passed by A, the National Assembly, with a supporting vote of at least 2/3 of its members, and B, the National Council of Provinces, with a supporting vote of at least 6 provinces. Subsection 3. Any other provision of the Constitution may be amended by a bill passed, A, by the National Assembly with a supporting vote of at least 2/3 of its members, and B, also by the National Council of Provinces with a supporting vote of at least 6 provinces, if the amendment, Roman 1, relates to a matter that affects the Council, Roman 2, alters provincial boundaries, powers, functions, or institutions, or Roman 3, amends a provision that deals specifically with a provincial matter. Subsection 4. A bill amending the Constitution may not include provisions other than constitutional amendments and matters connected with the amendments. Subsection 5. At least 30 days before a bill amending the Constitution is introduced in terms of Section 73, Subsection 2, the person or committee intending to introduce the bill must, A, publish in the National Government Gazette, and in accordance with the rules and orders of the National Assembly, particulars of the proposed amendment for public comment, and B, submit in accordance with the rules and orders of the Assembly those particulars of the provincial legislatures for their views, and C, submit in accordance with the rules and orders of the National Council of Provinces those particulars to the Council for public debate if the proposed amendment is not an amendment that is required to be passed by the Council. Subsection 6, when a bill amending the Constitution is introduced, the person or committee introducing the bill must submit any written comments received from the public and the provincial legislatures, A, to the Speaker for tabling in the National Assembly, B, in respect of amendments referred to in subsections 1, 2, or 3B, to the chairperson of the National Council of Provinces for tabling in the Council. Subsection 7, a bill amending the Constitution may not be put to the vote in the National Assembly within 30 days of its introduction if the Assembly is sitting when the bill is introduced, or B, is tabling in the National Assembly if the Assembly is in recess when the bill is introduced. Subsection 8, if a bill referred to in subsection 3B or any part of the bill concerns only a specific province or provinces, the National Council of Provinces may not pass the bill or the relevant part unless it has been approved by the legislature or legislatures of the province or provinces concerned. 9, a bill amending the Constitution that has been passed by the National Assembly and where applicable by the National Council of Provinces must be referred to the President for assent. Close the quote. Honourable members, unlike our Constitution, Section 74 of the Constitution of the Republic of South Africa does not provide for amendment of the Constitution through any other procedure other than through its National Assembly and the National Council of Provinces. It also does not contain a provision for submission of the amendments to referendum or amendment by popular initiative. In my view, Article 255, Clause 1 of the Constitution of Kenya expressly provides what constitutes its basic structure and provides a safeguard against the arbitrary and whimsical amendment of the matters it lists without submission of the amendment to the people for approval. Indeed, honourable members, the preamble to the Constitution speaks to matters listed under Article 255(1) as it provides that, and I quote, "We, the people of Kenya, recognizing the aspirations of all Kenyans for a government based on essential values of human rights, equity, freedom, democracy, social justice, and the rule of law, exercising our sovereign and inalienable right to determine the form of governance of our country, and having participated fully in the making of this Constitution," close the quotes. As such, I am of the considered opinion that a bill may be introduced to amend any provision of the Constitution, and that such a bill may be considered and passed by the House subject to its submission for approval by the people at a referendum, if it touches on any matter listed in Article 255(1) of the Constitution. As I've guided in the preceding portion of this communication, and as noted by the report of the committee, the bill before the House does indeed touch on various matters listed under Article 255(1) of the Constitution. This does not invalidate the proposals, but merely subjects them to submission to a referendum. Honourable members, the discussion on the basic structure of the Constitution leads us to the question of whether the bill contains constitutional amendments. As you are aware, Article 3 of the Constitution, which deals with defense of the Constitution, and Article 10 of the Constitution, dealing with the national values and principles of governance, place an abiding obligation on the Speaker to respect, uphold, and defend the Constitution. As an extension of this constitutional imperative, Standing Order number 47, subsection 3 of the National Assembly Standing Orders requires the Speaker to, among other considerations, assess the constitutionality or otherwise of business proposed for introduction into the House. Standing Order number 47, subsection 3 provides, and I quote, "If the Speaker is of the opinion that any proposed motion, A, is one which infringes on the debate, on which is likely to infringe any of these standing orders, B, is contrary to the Constitution or an act of Parliament without expressly proposing an appropriate amendment to the Constitution or the act of Parliament, the Speaker may direct either that the motion is inadmissible or that notice of it cannot be given without such alteration as the Speaker may approve, or that the motion be referred to the relevant committee of the Assembly pursuant to Article 114, subsection 2 of the Constitution." Honourable members, I note that at paragraph 557 of the report, paragraph 557 of the report isolates the second schedule of the bill, which, among other things, allocates the proposed 70 additional constituencies among the 47 counties, terming it as unconstitutional for its attempt to oust the application of Article 89, Clause 4 of the Constitution, proposed in the second schedule of the bill, without expressly amending Article 89 and its alleged lack of anchoring a substantive provision of the bill. Honourable members, paragraph 617 of the report additionally flags the proposed amendment at clause 43 of the bill empowering the Judicial Service Commission to receive complaints against judges, investigate and discipline judges by warning, reprimanding, or suspending a judge as a clawback on the independence of the judiciary and judicial officers, terming it as unconstitutional and critically requiring its urgent reconsideration at the appropriate time. Honourable members, apart from these two provisions expressly cited in the report on account of their apparent unconstitutionality, several members also did raise concern with the following clauses of the bill questioning their constitutionality. Clause 29 of the bill, which allows the appointment of the cabinet from members of the National Assembly. Clause 44 of the bill on the establishment of the office of the Judiciary Ombudsman and its effect on the independence of the judiciary. Clause 52 of the bill, which establishes the Constituency Development Fund. Clause 61 of the bill, which reconstitutes the Salaries and Remuneration Commission, and clauses 67 and 68 of the bill, which touches on the functions and powers of the National Police Service and the National Police Service Commission. Honourable members, Article 109 of the Constitution outlines the manner in which Parliament exercises legislative powers with regard to ordinary legislation. And I may quote 109.1. Parliament shall exercise its legislative power through bills passed by Parliament and assented to by the President. 2. Any bill may originate in the National Assembly. 3. A bill not concerning county government is considered only in the National Assembly and passed in accordance with Article 122 of the Standing Orders of the Assembly. 4. A bill concerning county government may originate in the National Assembly or the Senate and is passed in accordance with Articles 110 to 113, 112, 122 to, and 123, and the standing orders of the Houses. 5. A bill may be introduced by any member or committee of the relevant House of Parliament, but a money bill may be introduced only in the National Assembly in accordance with Article 114 of the Constitution. Honourable members, the standing orders of the National Assembly prescribe in detail the procedure to be followed with regard to the initiation of legislative proposals, pre-publication scrutiny of the proposals, publication of bills, introduction of the bills in the House, and their consideration including amendment, passage, and transmission to the Senate where applicable. As members will recall, I previously applied Standing Order 47.3 during consideration of ordinary legislation and other business before the House to exclude specific portions of the legislation or other business found to offend the Constitution or existing laws from debate. The procedure applying to ordinary legislation and other business, however, does not extend to a bill to amend the Constitution. Honourable members, Articles 256 and 257 of the Constitution prescribe express procedures governing the origination and processing of a bill to amend the Constitution by parliamentary initiative and by popular initiative, respectively. The two articles are straitjacketed and require any procedural maneuvering to strictly accord with their provisions. In respect to a bill to amend the Constitution by popular initiative, Article 257 is clear. And the relevant part, for purposes, I will exclude on members the other sub-clauses. Go to clause 7. If a draft bill has been approved by a majority of the county assemblies, it shall be introduced in Parliament without delay. 8. A bill under this article is passed by Parliament if supported by a majority of the members of each House. 9. If Parliament passes the bill, it shall be submitted to the President for assent in accordance with Article 256, Clause 4 and 5. 10. If either House of Parliament fails to pass the bill, or the bill relates to a matter specified in Article 255, the proposed amendment shall be submitted to the people in a referendum. 11. Article 255, Clause 2 applies with any necessary modifications to a referendum under Clause 10. Honourable members, Article 94 of the Constitution outlines the general role of Parliament with regard to the consideration and passage of amendments to the Constitution. Among its other roles, Parliament is placed under an obligation of protecting the Constitution at all times and promoting the democratic governance of the Republic. And this is provided for, honourable members, in Article 94, Clauses 3 and 4. Parliament may consider and pass amendments to this Constitution and alter county boundaries as provided for in this Constitution. Clause 4, Parliament shall protect this Constitution and promote the democratic governance of the Republic. Honourable members, Article 257 of the Constitution qualifies the role of Parliament and its speakers with regard to the consideration of a bill to amend the Constitution by popular initiative. A close reading of Article 257 reveals 4 specific obligations relating to Parliament and the speakers of Parliament. A, receipt of copies of a draft bill to amend the Constitution and certificates of approval by the county assemblies. B, introduction in Parliament without delay, where a majority of the county assemblies approve the draft bill. C, passage by a majority of the members of each house. And C, submission of the bill to the President for assent if Parliament passes the bill. Honourable members, the text of this Article 257 deliberately limits the exercise of legislative powers by Parliament when considering a bill to amend the Constitution through popular initiative. Parliament has no role in origination of the bill and is only required to introduce the bill and pass or fail to pass it. Notably, whereas ordinary legislation may be lost in mediation or lapse for want of consideration, failure to pass a bill to amend the Constitution by popular initiative only propels it to mandatory consideration at a referendum by the people. Noting the limited legislative role afforded to Parliament and its members, inescapable doubts arise on the Speaker's role with regard to the substantive aspects of such a bill. Honourable members, as I've noted, by dint of Articles 3 and 10 of the Constitution and Standing Order 47.3, the Speaker's failure to arrest any business found to offend the Constitution or statute would amount to abdication of duty. I have previously ruled and guided members where such instances have arisen on the specific provisions of the Constitution that the proposals have offended, and additionally advised them to introduce amendments to the Constitution as an alternative. The bill currently before the House seeks to amend the Constitution. Consequently, challenging portions of the bill for ostensibly offending the same Constitution the bill seeks to amend would defy logic. Honourable members, in the report of the committee, the second schedule to the bill is termed, in quotes, unconstitutional for seeking to delimit constituencies, which is a function of the IEBC enumerated under Article 89.4 of the Constitution. According to the submissions made to the committee and those made by members on the issue of the perceived unconstitutionality of the schedule, would be cured if a direct amendment had been made to Article 89.4 of the Constitution. This position draws our attention to the history of the current Constitution and the mechanisms it put in place through the transitional and consequential provisions set out in the 6th schedule of the Constitution. Members will recall that drawing from the mandate outlined in the 6th schedule to the Constitution, this House functioned as both the National Assembly and the Senate for close to 3 years during the existence of the current Constitution. Additionally, honourable members will remember that my predecessor, the Honourable Speaker Kenneth Marende, had occasion to rule that the nominations made by the then President Mwai Kibaki to the posts of Chief Justice and Attorney General had been forwarded to Parliament in contravention of the provisions of the 6th schedule, which required consultations on the nominations with the then Prime Minister. The executive at that time and decided to operate within the Constitution and not obey the requirements of the 6th schedule. The names were subsequently withdrawn, and the nomination and appointment of Chief Justice William Mutunga strictly adhered to the provisions in the 6th schedule. Tellingly, honourable members, with regard to the first boundary delimitation exercise, the provisions of Section 27, subsection 3 of the 6th schedule define the obligation placed upon the IEBC to complete delimitation at least 12 months before a general election, provided for under Article 89(2) of the Constitution. Additionally, Section 27, subsection 4 of the 6th schedule protected all the constituencies existing at the time of the promulgation of the Constitution from being lost during the first boundaries review conducted by the then interim Independent Boundaries Commission, despite the existence of Article 89(4) in the main text of the Constitution. The existence of these constituencies has never been challenged, and the provisions of the 6th schedule have remained perfectly valid despite deviating from the substantive provisions contained in the main text of the Constitution. Honourable members, similar competing arguments may also be advanced with regard to the issue of the report on the constitutionality of the additional functions sought to be granted to the judiciary with regard to the disciplining of judges. According to the committee, in the event the bill is assented to without submission to a referendum, the cited provisions would be unconstitutional. I have a note that paragraph 377 of the report qualifies the findings of the committee by acknowledging that an unconstitutional amendment becomes constitutional if it is approved by the people in a referendum. Additionally, honourable members, at paragraph 506 of the report, the committee notes that there are provisions in the bill that touch on some of the matters provided for under Article 255, Clause 1 of the Constitution. Consequently, pursuant to Articles 255, Clauses 3 and 257, Clause 10 of the Constitution, the bill is one for which a referendum is required. Members will note that Clause 5 of the bill seeks to amend Article 31 of the Constitution, which provides for the right to privacy. Any amendment proposed to a provision of the Constitution contained in the Bill of Rights is protected under the matters listed in Article 255, Clause 1 of the Constitution, and must be submitted to the people for approval in a referendum. By this argument, therefore, the question of unconstitutionality of the provisions becomes moot, or at the very least premature, as the bill must be submitted to the people in a referendum. Any attempt by the Speaker to make a preliminary finding on the constitutionality of the provisions would be premature, speculative, and ultimately an exercise in futility. It would be tantamount to putting the cart before the horse. In any event, honourable members, Article 165, Clause 3, Paragraph D of the Constitution mandates the High Court to hear any questions on the interpretation of the Constitution and settle any contestations with finality. Indeed, I'm informed that currently the High Court has 8 consolidated constitutional petitions challenging the constitutionality of the entire BBI process and had issued an order precluding the President from assenting to the bill if passed by Parliament until the determination of the petitions. Petitions are listed below. Honourable members, the third issue, with regard to whether and to what extent the bill may be amended and the value and place of public participation in the consideration of a bill to amend the Constitution by popular initiative. The committee notes in paragraphs 364 and 65 of its report that the role of Parliament in considering a bill to amend the Constitution is not ceremonial, and that Parliament can amend the provisions of such a bill or correct any errors of form or typographical errors to bring drafting harmony to the bill. Additionally, the committee notes that, pursuant to the provisions of Article 257, Clause 10 of the Constitution, Parliament cannot replace or usurp the people's views on a popular initiative with its own. It therefore rules out amendments to a popular initiative bill, finding instead that the only changes that may be made to such a bill would be correction of any errors of form. Honourable members, let me allow these members who are shouting there to walk in. If you're coming in, please walk in. Make your way in, please, quickly. Take seats quickly, please, so that we can proceed with the business. Take seats so that we can proceed with the business. Members, take your seats so that we can proceed with the business. Those of you you can go to the tent. I'm sure you can follow. As honorable members will recall, I've had on previous occasion to address this issue at length in the 11th Parliament during the consideration of the Constitution of Kenya Amendment Bill 2015, sponsored by the member for Ugenya, the Honorable David Ochieng. Though the bill sought to amend the Constitution by parliamentary initiative, the issues raised then are substantively similar to those raised with regard to the present bill. Honourable members, in the communication issued on 20th of August 2015 on amendment of a bill to amend the Constitution by the National Assembly, I did guide the House that I would not allow any amendment to be proposed to a bill to amend the Constitution. The reasons given then, which similarly apply now, are that a plain reading of the operative provisions on amending the Constitution, the sanctity of the Constitution, and previously adopted procedure on constitutional amendments discourage such a practice. The communication noted the centrality of the people and their will in any process seeking an amendment to what they agreed to in the form of a social contract, and the need for precision in any attempt made to amend the Constitution as follows, and I quote, "The customs and traditions of our democracy have been to restrict amendment bills seeking to amend the Constitution. I see no reason to depart from this practice, as the Speaker cannot rely on allegory or allusion in guiding the House. Honourable members, you will note that the preamble to our Constitution highlights that the people of Kenya adopted, enacted, and gave themselves and future generations of this republic the Constitution. The sanctity of the Constitution as a social contract between the people of Kenya and not a document belonging to the Houses of Parliament, nor any other organ for that matter, is to be jealously safeguarded at every turn. And any process of its amendment is delicate and can only be undertaken with reference to a definite procedure that deviates from the ordinary. Honourable members, while Parliament has been given the power to amend the Constitution, we should be mindful that the Constitution belongs to the people of this republic. Treating the process of its amendment as akin to an ordinary legislation would subvert the collective will of the people. In this regard, it is expected that any person intending to amend the Constitution must be very clear and precise on what he or she is intending to alter, but not to change mind while in the process or midstream. It is my strong view that any proposal to amend the Constitution should be preceded by the meaningful and adequate consultations before such a bill is published, a principle embodied in Article 256, Clause 2 of the Constitution. Bearing in mind that the legislative power is originally derived and consequently vested in the people, we ought to obtain the confidence of our fellow citizens even as we endeavor to amend the Constitution. The process of making or amending the Constitution, therefore, cannot be without consultations, precision, and guarded restraint." Close the quote. Honourable members, in the same manner I was minded in 2015, I am still minded to disallow any attempts to amend the bill currently before the House. Indeed, I would say I am actually more persuaded to disallow any amendment for the sole reason that there is a bill to amend the Constitution by popular initiative. So, as noted in my opening remarks, once initiated, a bill to amend the Constitution by popular initiative is irrepressible to any attempts to delay or derail it. I am of the considered opinion that any attempt to amend the provisions of the bill directly negates the popular nature of the bill and the exercise of the sovereign will of its promoters, who have collected more than 1 million signatures of registered voters in its support and ostensibly convinced the majority of the county assemblies to approve without alteration. Honourable members, amendment of the text of the bill is markedly different from the correction of any errors of form that may be noted in the bill. Members will note in the report of the committee that the issue of the so-called errors of form is canvassed at length. This issue has generated considerable public debate on whether the errors exist and whether they materially affect the substance of the bill and can therefore be glossed over. Honourable members, having perused the bill received by the House from the IEBC, which is a bill that was read a first time on 4th of March 2021, I have noted that it contains the following typographical and cross-referencing errors. A, the marginal note to clause 48 of the bill refers to Article 189 instead of Article 188 of the Constitution. B, clause 51, paragraph A of the bill does not refer with adequate precision to the specific part of Article 204 of the Constitution that it proposes to amend. Honourable members, you will also note that in the report that discrepancies have also been identified in the bills received from the county assemblies in the returns submitted to the two speakers of Parliament. 12 county assemblies submitted bills with similar errors to the ones noted in the bill currently before the National Assembly. That 4 other county assemblies submitted bills which, apart from containing the errors noted in the bill before the House, contained the following additional errors. A, clause 13B of the bill seeks to amend Article 97, clause 3 of the Constitution, despite Article 97 of the Constitution not having any clause 3. B, paragraph 1, subparagraph 1 of the second schedule cross-references Article 87, clause 7 of the Constitution, which also does not exist. Honourable members, you'll agree with me that the errors highlighted in the bill before the House and in the bills received from the county assemblies are minor errors which do not affect the substance of the provisions of the bill. The errors are not material enough to impugn the entire bill, its processing by the House, and the intentions of its promoters. As rightly noted by the committee at paragraph 365 of the report, the legislative mandate of Parliament allows it to correct any errors of form or typographical errors that do not go to the substance of the bill to bring drafting harmony to the bill. Both houses of Parliament have, through their standing orders, donated this power to correct errors in a bill to their speakers before submission of a bill to the President for assent. Specifically, Standing Order 152, subsection 3 of the National Assembly Standing Orders provides that, and I quote, at any time before the certification of the bill, the Speaker may correct formal errors or oversights therein without changing the substance of the bill, and thereafter submit the bill to the President for assent. Close the quote. Honourable members, indeed, the Speaker has invoked this power in the past to approve corrections done to bills during the preparation of vellum copies of the bills for submission to the President for assent. In this regard, I shall invoke the power to correct the highlighted typographical and cross-referencing errors in the bill at the appropriate time. Honourable members, the determination that the bill presently before the House may not be amended logically begs the question of the need and value of public participation to the consideration of the bill. Article 118 of the Constitution, as read together with Standing Order 127, mandates this House to conduct public participation in its legislative business. This is a mandatory exercise that the House is enjoined to undertake when considering any legislative business. It is not discretionary or optional, as it is indeed also one of the national values and principles of governance provided for in Article 10 of the Constitution, which are binding on all state organs and state officers. Honourable members, in this regard, although Article 257 of the Constitution is silent on whether to conduct public participation as compared to Article 256(2) of the Constitution, which mandates Parliament to publicize any bill to amend the Constitution, Article 118, on the other hand, places a general obligation on Parliament to conduct public participation in all its legislative business. I also note that the joint committees in their report, as contained in paragraph 4 or 5, also did address this issue and found that Article 257 of the Constitution does not oust the application of Articles 10 and 118 of the Constitution on public participation. Having said this, honourable members, it is also worth noting that the courts have further prescribed the threshold of what is meaningful public participation, a fact that was alluded to by the member for Garissa Township, the Honourable Eden Duale, in raising his point of order. The thresholds are intended to ensure that this House, or indeed its committees, do not just engage in a ticking the box or cosmetic exercises in a bid to comply with the obligations set out in Article 118 of the Constitution and Standing Order 127. The process must therefore be qualitative rather than quantitative. In this regard, it is not the number of submissions that are made by stakeholders, or indeed the number of stakeholders that participate in such an exercise that matter. A committee must demonstrate that it did engage, consider, and examine the submissions made by the public in arriving at its decision. This, honourable members, can only be ascertained by a look at the report of the joint committees in the instant case. Honourable members, having said this, allow me to refer to a number of court decisions that have also made very imperative pronouncements on what is meaningful public participation. In the case of Robert N. Gakuru and another versus Governor of Kiambu County and 3 others in 2013, as reported in the Kenya Law Reports, it's observed that public participation ought to be real and not illusory, and ought not to be treated as a mere formality for purposes of fulfillment of the constitutional dictates. Honourable members, the High Court in Constitutional Petition number 282 of 2017, being Association of Kenya Medical Laboratory Scientific Officers versus the Ministry of Health and the Attorney General, it was further observed, and I quote, "Public participation is not mere consultation or a public relation exercise without a meaningful purpose," close the quote. Honourable members, looking at other jurisdictions like in South Africa, the same thresholds of public participation have been upheld. Indeed, referring to the famous case of Doctors for Life for International versus the Speaker of the National Assembly and others, in 2005, the court held that, and allow me to quote, "What is intimately important is that the legislature has taken steps to afford the public a reasonable opportunity to participate effectively in the lawmaking process. Thus, construed, there are at least 2 aspects of the duty to facilitate public participation. The first is whether to approve or reject the bill when the bill finally proceeds for a referendum. I am also satisfied that adequate public participation has been undertaken in respect of the bill, as the bill by its nature being a popular initiative and the public participation having been undertaken by the 2 committees jointly, an environment and opportunity was given to the public to have their say on the matter. Fourth, the question whether on the effect of the pending court cases, the following is the response. There currently does not exist any court order directed at Parliament with regard to the consideration of the BBI Constitutional Amendment Bill 2020. Standing Order number 89 of the National Assembly Standing Orders cannot oust the obligation on Parliament to introduce and consider a bill to amend the Constitution by popular initiative without delay. Number 5, that the procedure to be applied during the consideration of the bill in the House shall be having the bill read the first time, the bill shall undergo second reading, voting threshold applicable second reading, 176 members, voting shall be by roll call. I may, if necessary, direct the holding of a further vote at the various stages of the consideration of the bill pursuant to the provisions of Standing Order number 62. Honourable members, as the House henceforth proceeds with the consideration of the bill with this guidance, may I end by stating that, as your Speaker, it is my considered finding that the Constitution of Kenya Amendment Bill 2020, promoted by the Building Bridges Initiative, is properly before this House. Further, it is my view that in the reading of the Constitution, no state organ or person to whom power is delegated by the people under Article 1 of the Constitution can stand in the way of the exercise of the sovereign power of the people of Kenya to chart the course of their future in any manner they deem fit within the provisions of the Constitution. I therefore wish to urge honourable members that while debating and deciding whether to pass the bill or not, the House must always be mindful of the considerations that motivated the people of Kenya to make and reduce their current social contract into writing in the first place. The last 3 paragraphs of the preamble to the Constitution of Kenya encompass these considerations, where the people of Kenya, while recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law, and exercising their sovereign and inalienable right to determine the form of governance of the country, and having participated fully in the making of the Constitution, approved, enacted, and gave the Constitution to themselves and to their future generations. The centrality of the people to the making and amendment of the text of the Constitution cannot therefore be gainsaid. The House is accordingly guided. I thank you. What's the issue? Honorable John Bandi.
Thank you, Mr. Speaker. Mr. Speaker, first of all, let me thank you for your ruling, which is long, Mr. Speaker, but very clear. Mr. Speaker, I can't remember in my entire life in this Parliament any communication from the Speaker's office or from the chair, which is of this, the length of this communication cannot be compared to any other that I've come across. But, Mr. Speaker, there is just one clarity that I would want to request you to consider and maybe make it more clear. You did mention that according to the provisions of Article 257(8), that all the stages of this bill we will require simple majority. And you went ahead to mention the number at 176. Mr. Speaker, it may be a small matter, but may be very important in future. I wanted to ask Honorable Ketu Waiguru to allow the Speaker to let me make this my point. Mr. Speaker, Honorable Catherine Waiguru could allow Mr. Speaker to, yes. Mr. Speaker, what I was raising is the number of 176. It may look a small matter, but Mr. Speaker, when it comes to actual voting, the issue may arise. The membership of this Parliament is actually 350, including the Speaker. But the Speaker does not take a vote, and therefore the membership is basically 349. Now, if you divide 349 by 2, you get 174.5. Now, when you talk about majority, Mr. Speaker, out of that number, the majority is 175. Because if 175 supports the bill, then up to 174 can oppose the bill. So majority, Mr. Speaker of the House, would be 175 and not 176. So, Mr. Speaker, that is a clarity that I actually wanted, because the number is 175. Minority, the highest that the minority can garner is 174. But you mentioned 176. In the event that we manage to get 175, it may be ruled that the bill has not been passed, yet that is the required threshold, Mr. Speaker. So that is what I wanted to raise for your consideration. Thank you, Mr. Speaker. Your ruling was well executed. Thank you.
Thank you. Honourable members. Sorry, we are, let's not, we are actually just at the second order. Now, I wanted us, maybe we can deal with these other issues. We can deal with these other issues when we get to, because this business is there anyway. I'll deal with that issue, Honourable Bandi. I think you have raised a valid point. A valid point. We'll deal with it. No, please, let's not. Sorry, unless maybe we have forgotten the rules, it cannot be subject of debate. You know that. It cannot be. So just to refresh your memory about the rules. So let me deal with that one administratively. No? Can we go to the next order? Next order.
Order number 3,
okay.
Messages.
It will be provided immediately. The message. Is that the next order? No, messages. Honourable members, please let me just do this. We still have a lot of other procedural issues to deal with just now. If you allow me, let me just finish this. Honourable members. Now, honourable members, and you just remain where you are. Just remain where you are. We are on order number 3, which is messages. Honourable members, starting order number 41, subsection 4 requires the Speaker to report to the House any message received from the Senate at the first convenient opportunity. And in this regard, on April 19th, 2021, I did notify you of a message from the Senate regarding the passage of the Mang Beans Bill, Senate Bill number 9 of 2020. The Mang Beans Bill, which was published, find Kenya Gazette Note Supplement number 130 of July 24, 2026, among others, to provide for the development, regulation, and promotion of the Mang Bean sector in Kenya. The message conveys in part that the Senate considered and passed the bill with amendments on Tuesday, April 13th, 2021, and now seeks the concurrence of the National Assembly. Honourable members, standing order 143(1), paragraph A requires the Speaker to cause a bill received from the Senate to be read a first time upon conveyance of a message from the Senate referring the bill to the National Assembly. In this regard, I direct that the first reading of the bill be referred to the Parliamentary, after the first reading be referred to the Budget and Appropriations Committee office to offer the Speaker advice contemplated under Article 143, subsection 2. Thereafter, I shall guide the House and the Departmental Committee on Agriculture and Livestock on how to proceed with the consideration of the bill. I thank you.
Order number 4, Petitions.
Is there a petition? Honourable Manje. Honourable members, we were merely dealing with the first order, which was communication from the chair. Now we go into the rest. Now we are in petitions.
Thank you, Speaker. I, Joseph Manje, on behalf of leather and leather products investors and interested stakeholders in the country, draw the attention of the House to the following. That Kenya Leather Development Council, KLDC, is a state corporation established under Kenya Leather Development Council Order 2011 by legal notice number 114 of 2011 under the State Corporations Act. The Council is a specialized agency that provides advisory services on matters relating to processing and trading of hides and skins, leather and leather goods, overseas licensing in the leather subsector, enhances leather marketing strategies, and regulates, harmonizes, coordinates, and facilitates the growth of leather industry in the country. That KLDC was formed on a private-public partnership to represent the interests of the leather sector, with representation drawn from the Kenya Livestock Marketing Council, Slaughterhouses Association, Hinds and Skins Traders, Tanners, footwear manufacturers, informal leather manufacturing, and the academia. That the council was initially placed under the Ministry of Industrialization and Enterprise Development, where the leather sector was categorized as a flagship industry before being transferred to the Ministry of Agriculture and Livestock, where the core mandates of leather promotion is largely ignored or underfunded. That recently, the recent appointment of board members and the council's senior management have been unfairly skewed towards a particular region of the country, which has shifted the council's focus from promotion of leather and leather products manufacturing to hides and skins improvement, which is essentially a devolved function. That the council senior management has been undertaking unauthorized recruitment of staff and has presided over the closure of 3 tanneries, the massive decline in industry exports earnings, the increase of imported footwear, the liberatory, mislabeled second-hand footwear, the shrinking of the market for semi-processed leather and leather general marketing, and growth crisis currently being faced and leather industry in the country. That the council has failed to adhere to the prescribed government regulation to commenting constructions of 4 warehouses in Kinare, Machakos County under Kenya Leather Industry Park programs at a cost of 1.2 billion on a site that is yet to be surveyed and which belongs to the Export Processing Zone Authority. That efforts to have this matter resolved by the Kenya Leather Development Council in this petition are not pending in any court of law. Your humble petitioners pray that the National Assembly, through the Departmental Committee on Trade, Industry, and Cooperatives, 1, investigate the matter with a view to recommending urgent transfer of oversight of the Kenya Leather Development Council from the State Development for Livestock to the State Department for Industrialization. 2, ascertain the qualifications of the board members and the council's senior management, as well as their commitment towards improvement of the leather industry. 3, investigate the controversial construction of warehouses on over 1,100 acres of land belonging to the Export Processing Zones Authority, the possible irregular reallocation of rights meant for common affluent treatment planned towards construction of the warehouses and the procurement and general planning of the project. And lastly, makes any other further recommendation that it deems fit in the circumstances of the petition. And your petitioners will ever pray. Thank you.
Very well. Petition referred to the Committee on Trade. Is it Trade and Industry?
Yes.
Very well. Next. Next order.
Order number 5, papers.
Leader Majority.
Honorable Speaker, I beg to lay the following papers on the table of the House today, Tuesday, May the 4th, 2021, afternoon sitting. Number 1, the 2021 to 22 Annex of Estimates of Revenue and Expenditure for State Corporations of the Government of Kenya for the financial year ending 30th of June 2022 from the National Treasury. Number 2, estimates of revenue grants and loans of the Government of Kenya for the year ending 30th of June 2022 from the National Treasury. Honorable Speaker, I wish members were paying more attention because we are talking about issues to do with loans, and this is a debate that is currently out there. Yeah, and then people will be asking that there is no information, yet the information is just in this House. Honorable Speaker, number 3, the financial statement for the national government for the year, fiscal year 2021-2022 for the period 1st of July to 30th of June from the National Treasury. Number 4, a report to Parliament on all new loans contracted by government from 1st of September 2020 to 31st of March 2021 from the National Treasury. Number 5, report of the Auditor General for the National Government for the financial year 2018 to 2019. Number 6, the report of the Auditor General for the National Government Affirmative Action Fund for the year ended 30th of June 2019 and the certificate therein. Number 7, the report, the Ethics and Anti-Corruption Commission 4th quarterly report for the year 2020, covering the period 1st of October 2020 to 31st of December 2020. Number 8, the status of the economy report from the National Treasury. Number 9, the 15th annual report for anti-corruption and economic crime cases for the period 1st of January to 31st of December 2018 from the Director of Public Prosecutions. Number 10, the 16th annual report for anti-corruption and economic crimes cases for the period 1st of January to 31st of December 2019 from the Director of Public Prosecutions. Number 11, the annual report and financial statement of the Teacher Service Commission for the year ended 30th of June 2019. Number 12, the annual report and financial statements of the Competition Authority of Kenya for the financial year 2019 to 2020. And lastly, which should be of concern to members, the National Government Constituencies Development Fund Board's report on project proposals, approvals, disbursement status, and restrictions imposed on constituency account for the third quarter of the financial year 2020 to 2021, that's covering the period 1st of January 2021 to 31st of March 2021. Thank you, Honorable Speaker.
And I think, honorable members, many of you who belong to the category of the 290, this is an important report because it talks about the National Government Constituency Development Funds Board report on project proposals, approvals, disbursement status, and restrictions imposed on constituency account for the third quarter for the financial year 2020-2021, January to 31st March. Many of you I've seen many of you trying to ask questions in a popular page. And But you are not, none of you is today even bothered about this report. But you will be posting some things asking about the same things. Next, Chairperson, Departmental Committee on Lands, Honorable Rachel Nyamai.
Thank you, Honorable Speaker. Honorable Speaker, I beg to lay the following papers on the table of the House today, Tuesday, May 4th, 2021. Reports of the Departmental Committee on Lands on its consideration of 1, a petition by residents of Kenyona Ward regarding safeguarding public interests in the use of Getuamba land in Kenyona Ward and of Murang'a County, and 2, a petition by members of Kaga Farmers Cooperative Society regarding liquidation of the society. Thank you, Honorable Speaker. I beg to lay the 2 papers.
Chairperson, Departmental Committee on Finance and National Planning, Honorable Wanga.
Honorable Speaker, I beg to lay the following paper on the table of the House today, Tuesday, May 4th, 2021. Report of the Departmental Committee on Finance and National Planning on its consideration of Excise Duty Amendment Bill of 2020. Thank you, Honorable Speaker. Honorable Speaker, now that we've gone to the bottom, I don't know how we are now going to manage again to speak on BBI, because when your light comes, you go down, and we came a bit early.
So you'll get. How did you get to the bottom? No, I noticed where you are. About what?
Also to raise the same concern, Honorable Speaker, because I am very keen to speak on BBI.
Yeah, I noticed where you are. I noticed where you are on the list.
Thank you very much, Mr. Speaker.
Next order.
Order number 6, notices of motion.
Leader of Majority.
Honorable Speaker, I wish to give notice of the following motion, which relates to the further alteration of the calendar of the House for the 5th session. Honorable Speaker, that pursuant to provisions of Standing Order number 28.4, this House further alters its calendar for the 5th session, regular sessions, and resolves as follows. Number 1, that the sittings of the House for the first part of the session terminate on Thursday, 13th of May, 2021, instead of 6th of May, 2021. Number 2, that the sittings of the House for the second week of May, 2021, accord with the resolution of the House of February 10th, 2021, with respect to the sitting days and times and prioritization of business. Number 3, that this House, that the business to be transacted during the morning sittings of Thursday, 6th of May, 2021, and Thursday, 13th of May, 2021, be exempted from the resolution of the House of February 10, 2021, in terms of the approval of calendar of the National Assembly regular sessions for the 5th session of 2021, being days allotted for business not sponsored by the majority party or minority party or business sponsored by a committee. And number 4, that the House proceeds for its recess from Friday, the 14th of May, 2021, instead of 7th of May, 2021, to accord committees time to consider estimates of revenue and expenditure for the national government, judiciary, and parliament for the financial year 2021-2022, and resumes on Tuesday, the 8th of June, 2021, to commence the second part of the session. Thank you, Mr. Speaker. That is the first notice.
The next.
Honorable Speaker, I wish to give notice of the following special motion on behalf of the Honorable Adan Kena.
How long are you likely to take?
Thank you, Honorable Speaker. Maybe 2 minutes?
How many?
2 minutes.
2 minutes.
Yes.
Very well, proceed.
I thank you, Honorable Speaker, for giving me this opportunity to make a response to statement raised by my colleague, Honorable Kaduru Murungi. And I've already shared, Honorable Speaker, the statement with him. So he raised, Honorable Speaker, 2 questions. Number one is that could the government consider giving university and college students more time to organize their travel, and by extension give them clearance or clear messages as they travel home, Honorable Speaker. Remember, Honorable Speaker, this question was, or statement was raised during the time when we were closing and COVID-19, and when the country, or some of the part of the country, was being closed or semi-closed, Honorable Speaker. That is on 30th of March. And this, Honorable Speaker, I raised on the same day, and I said that the ministry will quickly take action, Honorable Speaker. Therefore, the answer to the statement, Honorable Speaker, is that all our children were allowed free travel from the closed counties to their homes, Honorable Speaker. And therefore, nobody, or none of our children, Honorable Speaker, were not allowed to go home. All of them are allowed to go home, Honorable Speaker, peacefully. This was in coordination between the Ministry of Transport and the police, Honorable Speaker. And therefore, everybody went home safely. Number 2, Honorable Speaker, my colleague, Honorable Murungi, wanted to know, and I was asking, could the ministry intervene and direct the National Transport and Safety Authority, NTSA, to act with speed and rein on rogue matatu circles who are hiking fares across the country, and consider suspending their operating licenses, Honorable Speaker. At that particular time, of course, there was a rush, Honorable Speaker, for people leaving the closed counties. And, Honorable Speaker, the response of the statement is as follows, Honorable Speaker, in this question, that the Public Service Vehicles, PSV, subsector is governed by the Traffic Act, Cap 403, and also National Transport and Safety Authority Act, number 3 of 2012, and also regulation, Honorable Speaker. What does that mean? It means, Honorable Speaker, under these laws, there is no express provision in the 2 acts that enables the authority, that's NTSA, to regulate the fares as requested by Honorable Katuri, Honorable Speaker. There is no legal framework for NTSA to regulate those fares. However, Honorable Speaker, what we might advise Honorable Katuri is as follows, that in addition, the ministry is in consultation, Honorable Speaker, with the PSV transport stakeholders in the need to streamline the fares across the country, Honorable Speaker, noting the economic hardships that our country and our people are experiencing during this period of COVID-19, Honorable Speaker. And with those few remarks, Honorable Speaker, and responses, I thank you. And I've given this statement to Honorable Kadure himself, whom, Honorable Speaker, he called me back to say he is satisfied with the response from the Minister, Honorable Speaker. I have shared this with Honorable Kaduri, Honorable Speaker, and he called me to say that he was satisfied with the statement, Honorable Speaker, and therefore I thank you.
So the Honorable Kaduri is not present. The Honorable Kaduri Murungi?
Honorable Speaker, I have not seen him, but I talked to him, he called me earlier.
Very well.
Thank you, Honorable Speaker.
Next order.
Okay.
Next order.
Order number 8, the Foreign Service Bill, National Assembly Bill number 8 of 2021, first reading. A bill for an act of Parliament to provide for the establishment, management, administration, accountability, and functioning of a professional foreign service of the Republic of Kenya and for connected purposes.
Next.
Order number 9, the Mung Beans Bill, Senate Bill number 9 of 2020, first reading. A bill for an act of Parliament to provide for the development, regulation, and promotion of the mung bean sector and for connected purposes. Order number 10, motion, further changes to the membership of specified committees.
Leader Majority.
Honorable Speaker, I beg to move the following motion. That further to the resolution of the House of Tuesday, the 5th of December 2017, appointing members into various committees, and pursuant to the provisions of Standing Order number 173, this House further approves the appointment of the following members to the respective committees as specified hereunder. Number 1, the Honorable Peter Mwadhi, MP, to be appointed to the Departmental Committee on Administration and National Security to replace the Honorable Josephat Kafinga Wachira, MP. Number 2, the Honorable Joseph Kafinga Wachira, MP, to be appointed to the Departmental Committee on Labor and Social Welfare to replace the Honorable Peter Mwadhi. There's a swap between the two. Number 3, the Honorable Benjamin Dalus Stephen Tayari, MP, to be appointed to the Committee on Implementation to replace the Honorable Owen Yabaya, MP. Number 4, the Honorable Joseph Kalasinga Majimbo, MP, to be appointed to the Departmental Committee on Agriculture and Livestock. That's a new member getting a new committee. The Honorable, number 5, the Honorable Janet Ongera, MP, to be appointed to the Departmental Committee on Environment and Natural Resources to replace the Honorable Benjamin Dalu Stephen Tayari, MP. Number 6, the Honorable Teddy Gumbao Mwambire, MP, to be appointed to the Public Investments Committee to replace the Honorable Anthony Tom Oluoch, MP. Number 7, the Honorable Oscar Peter Nabulindo, MP, to be appointed to the Committee on National Cohesion and Equal Opportunity. Number 8, the Honorable Francis Tom Joseph Kajwang, MP, to be appointed to the Departmental Committee on Justice and Legal Affairs to replace the Honorable Otiende Amolo, MP. Honorable Speaker, these names were approved by the Selection Committee in its sittings yesterday. The names have been proposed by the political parties and the political coalitions through the whips, and basically is a reorganization of the committees to reflect some gaps, partly within the national security. There's a gap of leadership occasioned by the demise of the late Paul Koinange, and the Jubilee Coalition is proposing to fill that vacancy with the support of members by proposing the Honorable Peter Mwadhi to move in there, and hoping the members will then give him the support so he can continue the good work that the late Paul Koinange had started. And he creates a position then in Labour, which the Honorable Kafinga would occupy. But that will happen. The elections for that have not been declared, so that will be declared in due course. The 2 new members have joined, the Honorable Joseph Kalasinga Majimbo and Oscar Peter Nabulindo, and now they have been formally appointed into the committees. And there's also some reorganization by the NASA coalition for the better efficiency of delivery of services within their committees by their membership. I do not want to belabor a point. This is really something that, and some members have even asked to be removed or reallocated committees of choice. I see Honorable Bayer wanting that attention highlighted. So, Honorable Speaker, this is really a straightforward matter. It will receive unanimous support in the Selection Committee, and I'm sure this House, we don't even need to do a lot of debate on this. I beg to move and ask the Honorable Leader of the Minority Party to second.
Thank you, Mr. Speaker. Mr. Speaker, I want to second this motion. Mr. Speaker, the Selection Committee sat yesterday and did some reorganization for the better functioning of the National Assembly, And as the Leader of Majority has rightly put it, there are possibilities after the passing on of the Honorable Koinange, and I think and I hope and pray that my friend Honorable Peter Mwadhi would be given an opportunity, if he's voted by the members of that committee, to become the chair of that committee and continue with the task. That is a very busy committee, Mr. Speaker, in terms of requests for statements and questions that go to Security Committee. On the others is basically rearrangement. The Honorable Anthony Tom Oluoch had actually requested that he could surrender one of the committees to our very strong member, Teddy Mwambire, who has been only serving in one committee. And so I want to say that this will now accord Teddy Mwambire opportunity to serve substantively in the Public Investment Committee where he has been acting. There are other members, like the two new members who have joined us after the passing on of our two colleagues. They also now have an opportunity to substantively serve in the committees. Finally, Mr. Speaker, we have made some changes in the Justice and Legal Affairs Committee, again to align it with the aspirations and requests and the aspirations of the ODM and NASA coalition. Tom Joseph Kajwang is joining. He may not be a professor in law, but is the People's Chief Justice, and so is well versed in legal matters, and I wish him well in that committee. Thank you, Mr. Speaker. I second.
Member for Muranga, Member for Muranga, if you could find some seat. You appear to be heavily laden. Honourable members, I propose the question that further to the resolution of the House on Tuesday, 5th of December 2017, appointing members into various committees and pursuant to the provision of Standing Order 173, this House further approves the appointment of the following members to the respective committees as specified hereunder. 1, the Honourable Peter Mwadhi, MP, to be appointed to the Departmental Committee on Administration and National Security to replace the Honourable Josephat Kabinga Wachira, MP. 2, the Honourable Josephat Kabinga Wachira, MP, to be appointed to the Departmental Committee on Labour and Social Welfare to replace the Honourable Peter Mwadhi, MP. 3, the Honourable Benjamin Dalu Stephen Tayari, MP, to be appointed to the Committee on Implementation to replace the Honourable Owen Yabaya, MP. 4, the Honourable Joseph Kalasinga Majimbo, MP, to be appointed to the Departmental Committee on Agriculture and Livestock. Number 5, the Honourable Janet Ongera, MP, to be appointed to the Departmental Committee on Environment and Natural Resources to replace the Honourable Benjamin Dalu Stephen Tayari, MP. 6, the Honourable Tende Ngumbao Mwambire, MP, to be appointed to the Public Investments Committee to replace the Honourable Anthony Tom Oluoch, MP. 7, the Honourable Oscar Peter Nabulindo, MP, to be appointed to the Committee on National Cohesion and Equal Opportunities. And finally, the Honourable Francis Tom Joseph Kajwang, MP, to be appointed to the Departmental Committee on Justice and Legal Affairs to replace the Honourable Otiende Amolo, MP. Is it the desire of the House that I put the question? Honourable members. Honourable members, let me just find out what is the mood like. So I put the question Will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? Nay. The ayes have it, honourable members, and I therefore put the question. Which is that further to the resolution of the House on Tuesday, 5th of December 2017, appointing members into various committees and pursuant to the provision of Standing Order 173, this House further approves the appointment of the members as listed on the order paper into the various committees to replace members as indicated in the order paper. Will as many as of that opinion say aye?
Order number 11, special motion, consideration of a nominee for appointment as Principal Secretary in the State Department for Implementation of Curriculum Reforms. Second, resumption of debate.
No, not put the question. Move to reply. Can I put the question for the mover to reply? Honourable members, again, it's your decision. You know, I don't have a vote. I put the question, which is that the mover be called upon to reply. Will as many as that opinion say aye? As many as counter opinion say nay? The ayes have it. Mover. Mover, Honourable Florence Mutua.
Thank you, Mr. Speaker. Mr. Speaker, I beg to remove my mask. I think I'm far away from. Huh? Misawa. Thank you, Mr. Speaker. Mr. Speaker, let me take this opportunity, first and foremost, to thank you and the Leader of Majority for saving the report last week. That was your very good wisdom, Mr. Speaker. Mr. Speaker, I also want to thank the honorable members of the Committee on Education and Research, Mr. Speaker, and the members who gave their views in support of Honorable Fatuma, and also the members who gave their various views. Mr. Speaker, but I have to explain why we were supporting this lady. Okay. Mr. Speaker, I want to thank all the members in support of one Professor Fatuma Chege, PhD, as the nominee for appointment as Principal Secretary, State Department of Implementation of Curriculum Reforms. Mr. Speaker, I had a lot of notes and explanations as to why the CBC rollout is important, but Mr. Speaker, seeing the mood of the House, I beg to reply. Thank you.
Honourable members, I think, if we can all pay attention, we'll move very fast. Honourable members, I put the question that taking into consideration the findings of the Departmental Committee on Education and Research in its report on the vetting of a nominee for appointment as Principal Secretary in the State Department of Implementation of Curriculum Reforms, laid on the table of the House on Wednesday, April 28, 2021, and pursuant to the provisions of Article 155, Clause 3, Paragraph B of the Constitution and Section 3 and 8 of the Public Appointments Parliamentary Approval Act 2011, this House approves the appointment of Professor Fatuma N. Chege, PhD, as Principal Secretary, State Department for Implementation of Curriculum Reforms. Will as many as what opinion say aye? Aye. As many as counter opinion say nay? The ayes have it. Next order.
Order number 12, special motion, appointment of a Clerk of the National Assembly.
Leader Majority.
Hold it. We need to move. Honourable Speaker, I beg to move the following special motion. That pursuant to the provisions of Article 126, subsection 6B,
127.
127, subsection 6B, and 128(1) of the Constitution, and in furtherance of the resolution of the Parliamentary Service Commission of 7th of April 2021, this House, A, approves the appointment of Mr. Michael Rotich Sialai, CBS, as Clerk of the National Assembly on contractual terms with effect from 26th of May 2021 and ending on 31st of July 2022, and B, calls upon the Commission to commence the process of recruiting a new Clerk of the National Assembly not later than February 22, so as to ensure a smooth and seamless transition. Honourable Speaker, from the onset, I wish to commend the Parliamentary Service Commission for appointing our clerk, Mr. Sialai, for a one-year contract upon retirement. And indeed, this move was geared to ensuring that we have a smooth transition, not just within that office, but as we come to the tail end of this Parliament next year. And in light of some of the issues that we are discussing within this House, including constitutional amendments that could occasion a whole reorganization of this House and a whole reorganization of our standing orders, you actually need a steady hand who has gone through similar things in the past and can take us through in the future. Honorable Speaker, for members who may not know Mr. Sialai, apart from seeing him here, he has a long and decorated career in the public service, having joined the public service as far way back in 1989, when some of the members may still have been in early childhood. Starting his job as a teacher of history and Kiswahili at Kimulo Secondary School, later assistant lecturer at Kericho Teachers College, until 1995, when he joined this Parliament as a clerk assistant. And he has risen through the ranks all the way to clerk of the National Assembly. Mr. Speaker, like I said, we are at a very important phase in this Parliament. Potentially, with the passage of BBI, this Parliament could be changed from the way we know it to the Commonwealth or the hybrid system. It will require a number of legislation to be passed. It requires some reorganization of our standing orders, and we need that expertise of Mr. Sialai, which can come in very handy to occasion this reorganization. Most importantly is that most of the employment contracts in the public sector have some inbuilt terms that end with the possibility of an extension for the standard person. And usually, it's like you have this subject to a reorganization. And hence, in taking this decision, the Parliamentary Service Commission is within its legal powers to actually exercise that discretion to extend the contract through the terms through a contract. Members may be aware of the several civil servants who are currently serving on contract, and perhaps the most notable is Joseph Kinyua, who was my PS when I was in the Treasury, has done a splendid job, is actually gone past the retirement age, but because of his experience and the way he handles the matters of the state, His Excellency President Uhuru Muigai Kenyatta has kept him up to this point, and there's no indication as when he will be let go, much as he has always wanted to retire like 5 years ago. But it's the kind of expertise you feel you need some safe hands, somebody who understands the mechanics of government to help, especially in very difficult times. Mr. Sialai has assisted this commission to discharge efficient and effective services to promote the ideals of parliamentary democracy as contemplated in Article 127. And he's already putting in place a very important project occasioned by COVID and the realities of the new normal in terms of facilitating virtual sittings of the House, including all this online voting and online participation, which is something that we would not want to be disrupted. Mr. Speaker, sir, it's also important to note that the Parliamentary Service Act, neither expressly nor by necessary implication, does not bar the Commission from engaging any person on contractual basis in any position within the Parliamentary Service. And Section 26(2) of the Parliamentary Service Act, number 22 of 2019, only provides that if the person appointed as clerk of a house is an employee of the Commission serving on a permanent and pensionable terms, the person shall continue on permanent and pensionable terms for the duration of the term, or retire from parliamentary service upon attaining the age of 60 years, whichever is the earlier. So it provides for when you must retire, but does not bar the commission on recognizing the talent and then extending on a contractual basis. So I just wanted that for avoidance of doubt, so that people do not start bringing issues that are, we know within the law. So, like I said, we want to congratulate the Commission for the decision which was made in accordance with our Constitution, in accordance with the Parliamentary Service Act, and in accordance with due consideration having been made to several factors in terms of the rare knowledge, the optimum performance of the duties of the clerk, and the need to have stability and continuity in that office, the provision of non-partisan and impartial advice, the maintenance of honesty, accountability, and integrity, and we've seen very good remarks being passed in the various pages. But most importantly, the need to ensure that we have a smooth transition through an orderly transfer of this function, hence the need to have the person in place, so that by the date the commission is being given that you must appoint a new person by February 2022, then we will have enough time for the incoming Clerk of the National Assembly to understudy the outgoing, and the 13th Parliament will be far much better through having created that transition mechanism between February and July, when the handing over process will take place. So, Honourable Speaker, I'm hearing the mood of the House, and I don't want to keep that decision any further. I beg to move and ask the leader of the minority party to second.
Thank you, Mr. Speaker. Mr. Speaker, I don't think there is much to say. We all know CLI, so either we decide to approve or we don't approve. There is nothing really to add. The leader of majority has said it all, and all the reasons behind it, I second.
Now, these ones, are they coming in, or are they? You're in various stages of. Now, members, you know, when you say various stages, some years back, a former member for Suba North, you may not have read this because it may be history. Some years back, when we used to have provincial commissioners, one former provincial commissioner of Nairobi decided to mount a raid in various places where people go to enjoy themselves. And in one place along Ronan Gala Street, some building known as Imani, he claimed in his press conference that he found people in various stages of development. So I was wondering whether the members who are walking in or in those various stages, that's on a light note. Those of you who may have read will know the exact ones used. I propose a question that pursuant to provisions of Articles 127, Clause 6, Paragraph B, and 128, Clause 1 of the Constitution, and in furtherance of the resolution of the Parliamentary Service Commission of 7th of April 2021, this House, A, approves the appointment of Mr. Michael Rotich CLI, CBS, as Clerk of the National Assembly on contractual terms with effect from 26th of May 2021 and ending on 31st of July 2022, and B, calls upon the Commission to commence the process of recruiting a new Clerk of the National Assembly not later than February 2022, so as to ensure a smooth and seamless transition. It's the desire of the House that I put the question. Very well. Honourable members, then I put the question that pursuant to provisions of Articles 127, Clause 6, Paragraph B, and 128, Clause 1 of the Constitution, and in furtherance of the resolution of the Parliamentary Service Commission of 7th of April 2021, this House, A, approves the appointment of Mr. Michael Rotich, CLI, CBS, as Clerk of the National Assembly on contractual terms with effect from 26th of May 2021 and ending on 31st of July 2022, and B, calls upon the Commission to commence the process of recruiting a new Clerk of the National Assembly not later than February 2022, so as to ensure a smooth and seamless transition. Will as many as of that opinion say aye? Aye. As many as of contrary opinion say nay? The ayes have it. Thank you very much, and congratulations to Mr. CLI. Honourable members, next order.
Order number 13, the Constitution of Kenya Amendment Bill 2020, second reading, resumption of debate.
How many members are? Honourable members, again, let me just make this announcement because it's I have already 72 requests. Up to now, only 32 and a half have contributed to the bill, and the Honorable Githiaka Kiai, MP, was on the floor when the House rose. He had a balance of 3 minutes. Honorable Kiai, you have a balance of 3 minutes.
Thank you, Mr. Speaker, sir. I take up from where I left, and I want, Mr. Speaker, sir, to congratulate you for the ruling that you have made today. And it's very deep with a huge impact on which sets a precedent, and therefore it will be used in future parliamentary engagements on similar issue. Mr. Speaker, sir, you have already quoted extensively on the JLAC report, and I want to say that the JLAC report, I'm a member of that committee, and I'm proud to have participated in this momentous occasion of amending the Constitution. Mr. Speaker, sir, there are two issues that came out during the deliberations, and one of them was whether or not there was an error in that report. And the issue here was Article 87, Article 87.7 and Article 89.7. And I want to say that the error on the face of the record does not in any way change the substance of the report. If you look at what the report was discussing, the issue was about the delimitation of the constituencies. And if you look at the deliberations also, it was captured very well by the JLAC members, and I want to say that the article is not fatal. Mr. Speaker, if you look at Article 103 of the Constitution, you realize that it omitted subsection 2. It only has subsection 1, and then it continues up to subsection 3. Really, nobody has ever raised the issue of the legality or otherwise of the Constitution. And it has been in operation for the last 10 years without any issue. I want to submit and say that the two articles, 87.7, which does not exist in the first place, then Article 89.7, which was talking about the delimitation, the error on the face of the record is not fatal. The other issue, Mr. Speaker, is about the delimitation of the additional 70 constituencies. Mr. Speaker, I submit that the will of the people, the sovereign power of the people, is captured in Article 1, and that power lies with the people of Kenya. They have the mandate to change any section of the Constitution. They are the people who created the IBC. They are the same people who created that article. But under Article 1 of the Constitution, they have the exclusive mandate to amend any section of the law. They have the exclusive mandate to make any law in this country. So, Mr. Speaker, I support.
Member for Limuru.
Thank you, Honorable Speaker, for giving a chance to contribute in this very important bill. And I start, Honorable Speaker, by also expressing my appreciation for your considered ruling that was quite informative, well researched, and one that will set precedent in future rulings in Parliament. It has put to rest most of the things. In fact, most of the issues that we were going to try and canvass, as I was discussing here with the Deputy Whip, were addressed in your ruling, and therefore I just want to really associate myself with that ruling. Honorable Speaker, let me start by saying that I really appreciate the statesmanship that was shown by our President, together with the magnanimity that was also exhibited by the former Prime Minister, Right Honorable Raila Odinga, when they came together and did the handshake. Because the commencement of BBI and the bill before us now is a result of that handshake, and which was also supported by so many people. But in so doing, in the handshake, Honorable Speaker, I listened to the two great leaders, and they said that the country and the people are greater and bigger than themselves. And therefore, that's why they would relegate themselves to the will of the people, which among them would to ensure that they end the electoral violence that have been witnessed since the early 90s, all the way until 2007, when it culminated into almost a civil war. Honorable Speaker, the two gentlemen put aside their desires and their ambitions and said, for the sake of the people of Kenya, we are going to address the issue of divisive elections. Every time there is an election, Honorable Speaker, we ordinarily, previously, would lose close to 2 years. About 1 year before we go to elections, for people fearing to invest in our country, and so therefore would lose in terms of income. And immediately thereafter, another 1 year where uncertainty would crawl in because of political instability. But what this bill seeks then to do is to ensure that it encompasses most of the people from the region. By way, Honorable Speaker, of having seats which are now currently in Parliament, not that they are additional, being distributed within the Republic, in the manner that the leader of majority will then at that time become the Prime Minister, and his deputy becomes the Deputy Prime Minister, and so on. But more importantly also, Honorable Speaker, that the person who loses, and I want to remind members that the last elections was won by a small margin, and that means a whole huge percentage, almost the same number, were literally in the opposition. And this issue of the winner takes it all, and the leader of that other huge chunk, almost 50% of Kenyans, was left outside. But this bill now proposes to change the Constitution, Honorable Speaker, to ensure that inside this House we have the leader of official opposition, probably with his shadow cabinet checking on the government, while here. Otherwise, previously, it would be the case that the president and the deputy and that government would be formed, and then they become a tool to fight the opposition. Now the opposition is recognized by its own people in the manner that is provided in this bill. Honorable Speaker, allow me also to bring out an issue which in the region that I come from has been used by some of us to go and peddle lies to the common mwananchi that for us to be able to pass this bill, then we must check whether it contains the issues of their milk in the bill, whether it contains the issue of the tea in the bill, whether it contains the issue of coffee in the bill. And Honorable Speaker, this morning I engaged a colleague and asked, there's a time that milk, tea, and coffee were doing so well, and asked them which constitution it was that addressed the issues of those three or more of the income-generating activities. And they said they never saw anything in that constitution that we changed. They never saw anything written about milk, about coffee, about tea in that bill. But in this one, Honorable Speaker, and allow me to quote, there is a provision for Article 11A, Honorable Speaker, on economy and shared prosperity, and which, among other issues, 11A1C talks about sustainable sources of livelihood, including agriculture, pastoralism, and blue economy. And at the tail end of that article, then it says that Parliament shall enact legislation to give full effect to this article. I bring this issue because when we were discussing the issue of tea bill and coffee and agriculture, the same people who went out there to say there is nothing that is addressing those main income-generating activities within our region were not in this House. And I want to invite them to accept to pass this bill so that we can change the Constitution, and further, that if they are lucky to get back to this House, if it will not have been passed, then they can come address it under the laws that are required to be done under that Article 11A. Honorable Speaker, allow me also to mention about resource sharing, which is also very pertinent, and which we feel, and this is my submission, that in Kenya, we know there were historical injustices. And the historical injustices, Honorable Speaker, were such that some areas were left behind when others were developing. But when we gave ourselves the Constitution of 2010, we found it fit, and the people of Kenya found it fit, that we should introduce money in the name of Equalization Fund so that we can try and help those areas that were left behind. Now, in the same vein, Honorable Speaker, if we are going to amend the Constitution, we should amend it in a manner and in a way that we are not going to marginalize or create another marginalization for areas that probably are perceived to have received development during that time. And I say this because, Honorable Speaker, there's a time I did my math and I looked at the money that is sent, the devolution, the money that is sent as devolved funds to each of the counties. And you'll find this money, if you check the amount that has been given per head, if you take the amount and divide it with the population, Honorable Speaker, you'll find in some areas that some people have got an equivalent of 7,000 and others have got an equivalent of 24,000. But in these changes, Honorable Speaker, and specifically in Article 203, and you will also allow me to quote, Honorable Speaker, that Article 203 shall be amended so that in 50A, and we address the need to ensure that the average amount of money allocated per person to a county with the highest allocation does not exceed 3 times the average amount per person allocated to a county with the lowest allocation. So that Honorable Speaker, speaks to the new marginalization that is coming and the injustice that will be done to the places and counties that have got so many people once you do the maths per head. Honorable Speaker, sorry, Honorable Speaker, I lost some document. Honorable Speaker, I also want to speak to the issue of CDF. Honorable Speaker, it is not lost on us that this House spent a whole year trying to address the issue of CDF, which had been ruled unconstitutional by the High Court. And during that time, and I dare say this, that CDF has been felt on the ground, Honorable Speaker, more than any other fund, be it devolved or otherwise, that it was so useful for members of parliament to have CDF. But what happened when we went to court? They ruled it that it was an illegality, that it was unconstitutional, and it was stopped. Honorable Speaker, I am elated, I am delighted that this time around, CDF is embedded in the Constitution, and that this House will enact legislation to operationalize how CDF will be distributed. Honorable Speaker, on top of that, I also would like to quote that we have the devolved money, which was pegged at 15%, equitable share to every county, now moving from 15% to 35%. And Honorable Speaker, not only is it moving from 15% to 35%, that further that 35% by the Constitution has got another 5% which is allocated to the ward. What does that mean? It means, Honorable Speaker, that the money which is being devolved to the counties is further devolved and gets closer to the people. And it's a requirement by the Constitution and by PFM that when there is development to be done in every county, Honorable Speaker, then the governor and the leadership at the county level must involve the people. And if we are going to involve the people, then, Honorable Speaker, it means the empowerment which the people are going to get has this neo terminology which came the other day, probably 2 days, that is a bottoms-up approach. Currently it's happening. We don't want to promise people what will happen. It should happen now, that once we pass these changes in the Constitution, we are going to have the bottom-up approach now, not beyond 2022 or after 2022. So those people who speak in terms of doing it after 2022 should be told we saw it longer time ago, that we are doing it now under BBI. Honorable Speaker, allow me also to speak to the issue of the second schedule, and I'm happy that you ruled there is nothing unconstitutional about the constitution making by the people, because they give themselves that constitution as long as they follow the clauses and provisions of how they should change that constitution. Because I had here some of us try to say that there needs to be amendments to a schedule within the Constitution. The people of Kenya can decide how many constituencies are going to be in Kenya. Honorable Speaker, I remember when I was here first in 10th Parliament, we had 220 constituencies. But when we gave ourselves the 2010 constituencies, then the people decided it is not going to be 220, but it's going to be 290. We were right. 290. But now I'm asking, what is wrong with us, the same people of Kenya, deciding that we want to have another 70 constituencies and make it 350? So if we removed from 210 to 290, can't we take it to 350? And indeed, also ensure that we decide which manner it is going to be distributed. Not that we are doing delimitation. The delimitation is for IEBC. but we are doing allocation of 70 constituencies in a manner that is supported by the second schedule. So with those many remarks, Honorable Speaker, I urge all of us to support, and I also thank members.
Top on the list is Luyai Amisi of Saboti. Of course, we'll be going using the system that the Speaker set of going by the list, not necessarily the sides of the House. So, Amisi.
Thank you, Mr. Speaker. Allow me to put my mask aside for a while. Thank you, Mr. Speaker, for giving me this chance. I've been waiting patiently throughout last week to no avail, but at least I learned the trick of being an early bird, and I've catched your eye. So, Mr. Speaker, 2010 Constitution was heavily borrowed from other advanced democracies and jurisdiction. And we do not, as a country, exist in vacuum. We are in a global setup where we learn from other nations. And a good example is Switzerland. Switzerland have a very interesting model of rotational presidents. And they aligned this to their distinct, multilingual, multi-ethnic composition of the country. As a country, we also have a distinct composition of our nation, and we must align our constitution to that reality. And I think the time is now, Mr. Speaker. Mr. Speaker, I'm so much excited. There's so much we can talk about this particular proposal in this bill, but I'm so much excited on a number of legislative proposals that have been proposed in this particular report. And most importantly, the one touching on the HELB, Higher Education Loans Board, that gives a 4-year moratorium to loanees. Mr. Speaker, I had a problem when I was vying as a member of Parliament, because one of the requirements was for you to produce a certificate that you've been cleared by Higher Education Loans Board. And Mr. Speaker, I had to take a loan to clear a loan. And you can imagine how many young people go through these difficulties of trying to clear their HELB loan for them to access opportunities. This particular legislative proposal, Mr. Speaker, is going to help the many graduates who are out there who get into problems of trying to access opportunities simply because one of the requirements is that they have to clear themselves with the HELB loan. And yet, at that time, for example, in my case, I was still jobless. I was looking for a job to come to this Parliament to represent the people of Saboti. So how do you expect a jobless graduate to get? So this proposal, Mr. Speaker, are some of the reasons that the young people of this country are going to support the BBI report. The proposals on micro and the small enterprise bill, Mr. Speaker, this one gives a 7-year tax break, a 7-year tax holiday to use on businesses. Mr. Speaker, I led a consortium of young youth organizations, young leaders, to present views to BBI task force. And this was actually my proposal, and I'm happy it was well captured that the young people needs to be given an incentives to uplift their businesses. And this is will go a long way if the bill comes to pass. The business incubation centers to provide advisory services. The Youth Commission, Mr. Speaker, our earlier suggestion was to make it a full-fledged ministry. But nevertheless, this was a step towards the right direction, because the Youth Commission will be in charge of formulating policies that will now enable the 70% of young people that makes the 70% of our population to participate, to take part in the art and craft of nation building. Mr. Speaker, the legislative proposals on Anti-Corruption and Economic Crime Act is also an exciting proposal here because we've lost so much as a nation through the graft musketeers, and it is now time to tighten our laws to provide enough, punitive laws to enhance our economic fight against economic crimes. Mr. Speaker, there's also legislative on National Economic and Social Council Bill to provide a comprehensive legal framework that our national planning is premised on. Mr. Speaker, we've left our national planning and economic social planning to political promises, that whatever the presidential aspirants promise the country is thus where our country will go. Now, Mr. Speaker, this has been risky to our nation because most of these promises are never fulfilled. So we need a council, an economic council, that will guarantee this nation a clear plan. You've seen the American, how they have designed their federal reserves. Even at times like now, during the pandemic, they are less affected because they have enough federal reserve to cushion their members of their citizens. So this is also a very progressive national planning bill that has been captured here. Of course, there are areas established under Clause 16, page 31, that provide the establishment of the leader of official opposition. Although, Mr. Speaker, there will be a problem if the leader, because the leader of official opposition must be the person who got the second highest votes in the presidential campaign. And he must come from a party or a coalition of party with at least 25% of the members of the National Assembly. There will be a problem, probably, if that leader is the second in the presidential campaign, but his membership in the National Assembly is not 25%. So does it mean that that parliament will lack the official opposition leader? So that's maybe the promoters of the bill, they look at that going forward. On Clause 28, on the appointment of the Prime Minister, we all agree that this is where we need to be as a nation to balance our different ethnic composition to allow at least various regions represented in the management of our country. The mixed cabinet to allow members of the National Assembly to be appointed as ministers or assistant ministers. Mr. Speaker, this one is also good, only that the word may, maybe a rogue president in future may use that to just have 2 members from his cabinet coming from the National Assembly and the rest comes from outside. So that's just areas that we need to look at going forward. The delimitation of boundaries, there is this argument that the BBI task force took away the mandate of the IBC. I don't see anywhere in this document where they have taken away the mandate of the IBC. The IBC will still delimitate the boundaries. So this argument, Mr. Speaker, the only areas we need to look at that 12 months before the general election, doing boundaries may be catastrophic or cause chaos towards the elections, especially in very highly tribal emotive areas like where we come from. These are areas, these are very minor things that we cannot stop a whole such big, nice document from passing. These are just areas that they can be looked at going forward. Mr. Speaker, we need to recognize where this nation has come from. Some of us, we've been in the center of NASA demonstration. We've gone to the streets. We've felt tear gas I'm one of the person who actually took or consumed a lot of tear gas. That tear gas canister was thrown right inside my car through the rear window. And were it not for the journalists of international media who are trained to save life as they take their footage, I could be dead. And most members here, Honorable Lochia is walking as if he's leaning. You may think he's on a bounce, but is having effects of demonstration and fight for what you believe in.
Honorable member for Hamisi, you know, I think the members might really have to applaud you, because if you really can consume tear gas and survive consuming, you know, the normal throwing of tear gas and sniffing is not the problem. But if you are a consumer, you proceed.
Mr. Speaker, I hope you'll give me back those minutes. But I'm using the word consume because it's actually what happened. I consumed because the tear gas was thrown right inside. I'm using that word carefully so that to capture the magnitude of the scenarios what we went through. It was a consumption of tear gas. And you may laugh at it, but Mr. Speaker, if it was not for a journalist from international media, I could have died. I could have faced people could have gone for a by-election merely 2 weeks after being sworn in. Up to now, I still visit Nairobi Hospital for checkup for my health. So it is, I see members of our formation, a certain formation, when they see a cigarette lighter in their rallies, they run helter-skelter thinking it's tear gas.
What is it, Honorable Chieng? What is it? What is it? What is out of order?
Sorry, Mr. Speaker, sir. I think the Honorable Hamisi, you only consume alcohol. You inhale. You inhale if you have opportunity that the police have thrown a tear gas onto you. The right English word is inhale.
Well,
thank you.
But sitting where I am as a lawyer, you know, you can still consume tear gas through the nose. So, proceed.
Mr. Speaker, that is wrong English. Thank you.
Proceed, Honorable Hamisi. That's exactly the issue
Mr. Speaker, Mr. Speaker.
But consumption is still getting it into your system. So you consumed it through the nose. Proceed.
Mr. Speaker, I was taught English by Dr. Griffin at Starehe Boys Center. And consume is an idiom, my friend. When you use consume, it's just an idiom in English language. So it doesn't necessarily need to speak your local language. But Mr. Speaker, I hope all those few minutes that you have gone, you'll give me back. I was trying to explain the magnitude of where this country has come from to reach. And nations have gone to war to reach where we are. But the two principles, the President and the Right Honorable Raila Amolo Odinga, they catapulted this country from war to peace. It is not easy. It has never happened. We must take this moment. We must reflect on it. Countries are taking Kenya as an example because the aftermath of any war is eventually peace agreement and justice. But here we are, a nation that was almost at the brink of war, was saved by two, statesmen. And this is a conversation we need to have as a country. Mr. Speaker, every generation in this country has fought for something. Every generation has risen up from the colonial time, fight against colonialism, fight against multipartyism. Every generation has risen up and done what needed to be done at that particular time. As a generation, we are now being called upon to rise up and do what needs to be done now. And what needs to be done now is to pass this document, this BBI that binds us as a nation. We must, Mr. Speaker, yes, this BBI bill, we must, Mr. Speaker, disturb the stubborn status quo. We must rise up. We must trespass on the taboos of the nationalism. Even when Obama was here, Obama told us that we've not inherited this land from our forefathers. We have borrowed it from our children, and we must return with interest. And the interest we are going to give to our children is this BBI. For this, Mr. Speaker, I support and I beg to support the report. Thank you.
Now, honorable members, we will follow the list as was asked by the Speaker, and that was ruled appropriately. Only that among the top 4, there are 2 members, among the top 4, there are 2 members who are actually going to be engaged in breaking the fast. And all of them will speak anyway. So I want to give an opportunity to Honorable Jaldesa, and then I'll give and please, because I have really tried to make it better for you, please return the favor by speaking less, because really it is something that, and then I'll give another member. Then we come back to the list, which the list is already there, and you are top 4. And you are the second.
Thank you. Thank you, Mr. Speaker, for giving me an opportunity to also add my voice on this very historical moment on behalf of the people of Isiolo. Mr. Speaker, just to put the record straight, I placed my card at 1 p.m. Therefore, you have not really done me a favor. I was on the top. Having said that, Mr. Speaker, from the onset, I want to take this opportunity to congratulate the committee of JILAC for doing a very good report. I was actually able to follow more the report they did than the BBI report itself. Therefore, I want to congratulate Mheshimiwa Muturi and his team for really simplifying the report and making it easy for us to understand. Mr. Speaker, it is said that politics is local and politics is about interest. And for the interest of the people of Isiolo, I stand here today to register a lot of reservation about this BBI proposal. Mr. Speaker, I'm saying this cognizant of a lot of ruling the Speaker made this afternoon. Mr. Speaker, to start with, the bill that is before this House, we are told it is a popular initiative. And my understanding is of a popular initiative is that this is a people-driven process. But Mr. Speaker, I have listened to people, I have interacted to people both from my constituency and even the constituency that hosts me, that is Nairobi. The ordinary people seems not to understand what BBI is all about. That begs now to raise a question. If it is really a people-driven process, how come people have not had an opportunity to see the copies of BBI document? How come civic education have not been conducted? Because I remember in 2010, we have been part and parcel of the process of civic education. We are given booklets. Even people used to knock doors telling us about the 2010 Constitution. Therefore, I'm just wondering really how it is a people-driven process. The county I come from, of Isiolo, people only know about BBI from what the politicians are saying. Those of us who are saying we have reservation, and those who are saying, oh, there is no perfect document, so even if we have reservation, we will pass it. So there's a lot of confusion, Mr. Speaker. Mr. Speaker, I have listened to some of my colleagues, and they are saying, you know, there is no perfect document. And the Constitution is a process. But then I ask myself, if there is no perfect document, now that we had a 2010 Constitution, and we have gotten to know the challenges that are there, why can't we improve on the 2010 Constitution other than creating more confusion? Having said those, Mr. Speaker, I want to go to the issues
that I have specific reservation. My reservation number one is on the issue of representation. Mr. Speaker, looking at the BBI report, and especially on the consideration for the 70 seat, they have looked at one man, one vote principle. Well, I agree that each citizen's vote is of equal importance. I'm equally concerned about how this principle can be applied, because Kenya is defined with its people and the land. Therefore, Mr. Speaker, if you will have been given an opportunity, I will propose we consider the one man, one vote together with 1 kilometer, one vote, so that we have a fair representation. And I will go further to even propose, because as the Secretary General of Pastoralist Parliamentary Group, we did a submission to the task force, and we say, to be fair to this country, let us also consider those people with populous constituencies and also those of us with huge land. And we said, let us give each county 1 seat, and the remaining 23 can be shared by the populous county. I hope if that is taken care of, Mr. Speaker, this document will go without any reservation. On the same note, Mr. Speaker, I am concerned about the removal of the 47 women representatives from this House and taking it to the Senate. In my view, Mr. Speaker, that is taking us back on all the gains we made. It is like giving with the right hand and taking away with the left hand. Why am I saying so? Mr. Speaker, the 47 women representatives in this House, in a great way, managed to address the gender gaps. Secondly, Mr. Speaker, it gave women political voice, because those of us who are elected, when we stand here with people behind us. It also took away the notion that the women who are nominated are either flower girls or slay queens or girlfriends of the party bosses. Now, Mr. Speaker, this BBI is proposing to take women back to those old days. Because of that, Mr. Speaker, it makes me sad. Again, Mr. Speaker, in their Senate, they said the Senate will elect one man, one woman. Mr. Speaker, the current Senate is already past that. I can proudly tell this House, my county of Isiolo elected a woman who competed with 6 men to the Senate. Likewise, Wasungishu, Nakuru, and Machakos. Now, Mr. Speaker, when they are saying one man, one woman from the Senate, what will happen to the gains that we already made? Therefore, for me, Mr. Speaker, those are issues that are giving me reservation about BBI. My reservation number 2, Mr. Speaker, it is on shared prosperity. Mr. Speaker, much as a lot of counties are celebrating the proposal to devolve 35% to the county, which of course I highly doubt, because even the 15%, the counties are really struggling to receive the 15% from National Treasury. Mr. Speaker, when you read the preambles of BBI, it talks about very attractive things. It says about equity, inclusivity, you know, the lack of discrimination, and many, many other good things. But Mr. Speaker, if you go to the BBI report, Article 203N, and Mr. Speaker, allow me to read this one. It says, Article 203 of BBI Constitution proposes the need to ensure that the average amount of money allocated per person to a county with the highest allocation does not exceed 3 times the average amount per person allocated to a county with the lowest allocation. Mr. Speaker, first of all, I want to say the money that are allocated to the county is not for distribution to individuals. It is for service delivery and for general improvement of development. Mr. Speaker, the proposal of per capita allocation capping under section 50N in the bill is against the spirit of common good for all Kenyans and negates the gain made so far as the object and purpose of devolution is concerned. Why am I saying this, Mr. Speaker? Mr. Speaker, as it is, the current revenue formula, it is already discriminatory because most of the parameters used to allocate the resources, if you look at it carefully, it is pegged on population. And that is why most of our counties are getting very small allocation. With current allocation, Isiolo County is getting 25,000 per person, whereas Nairobi is getting 4,000. Mr. Speaker, if you follow this formula, my county will lose 1.6 billion. And if you tell me to pass this BBI report because I want to be in good books with the power to be, Mr. Speaker, all powers are local. Therefore, I have to fight for the interest of my people plus 6 or 7 other counties that are going to lose money. Mr. Speaker, the other thing that we are told in BBI is Ward Development Fund. I want to say if there is a county which does not have a Ward Development Fund, they need to send home all their MCS. Because for Ward Development Fund to be established, we don't need a BBI. All we need is a legislation in the counties to establish. And I can comfortably tell you, most of the counties have Ward Development Fund more than what is proposed in the BBI report. Mr. Speaker, sir, my other issue, the last one, because I want to allow other members to contribute, is about inclusivity. Mr. Speaker, the BBI report talks a lot about inclusivity, which really is a very good thing. However, Mr. Speaker, you cannot build a united Kenya if a certain group within the society are not understood or are not accepted by their fellow citizen. Mr. Speaker, why am I saying this? For example, Mr. Speaker, the pastoralist community, most of the minorities, my community included, are discriminated when it comes to access of government documents, such as identity card, passport, and a birth certificate, Mr. Speaker. Mr. Speaker, it is only in pastoralist counties and some other minority groups in Kenya, including the Kenyan Muslim, where a child who is born in a Kenyan hospital goes through a Kenyan education system, and upon attaining at the age of 18 years, is subjected to a tiresome, dehumanizing, and ridiculous vetting process, especially when attaining ID. Mr. Speaker, we are told some of these counties are neighboring the foreign countries. But Mr. Speaker, my county of Isiolo is said to be the center of this nation. Yet, my people are subjected to vetting. We made the presentation to BBI task force. I expected it to be addressed. Unfortunately, nothing is talked about. Therefore, Mr. Speaker, I have a very, very big reservation against BBI, and when the voting will be taken, I will vote no. Thank you.
You did not leave even a single second to your, and I thought actually you are going to be that fair, but you didn't. So what I'm going to do now is strictly follow the list, strictly. And these are the members who are going to speak in this order. Honorable Ongera, Honorable Shamala, Honorable Mboko, Honorable Mudhoni, in that order. Because, I mean, I would have expected some savings from that, and it did not happen. So we proceed now with Honorable Ongera. Wherever we will reach, that would be fine, but we still have an evening session. Proceed.
Thank you, Mr. Speaker, for giving me also this opportunity so that I may make my contributions to the Constitution Amendment Bill 2020. Mr. Speaker, let me from the on-rise say that I support this bill, and I would like to take this opportunity to thank you for making a very wise and sagacious ruling that this is a popular decision and it must go to the people. Mr. Speaker, as one of the promoters of this bill, it really made my heart very happy to see that you made that ruling. Mr. Speaker, sir, there are many good things on this bill. And sometimes we say that in a constitutional moment, such as this one that Kenya is going through, the greater good exceeds the lesser evil. And why do I say this, Mr. Speaker, sir? This constitutional amendment has not just come out of the blue air. It has not just come out of fun so that we are just saying we are amending the bill, the constitution for the sake of amending. Mr. Speaker, sir, we are amending this because many Kenyans have died because of no level playing fields and equal opportunities, particularly in the political arena. Mr. Speaker, sir, this constitutional moment has arisen because we know what happened in 2017, 2018, Mr. Speaker, sir, where many of us, particularly we in the opposition, felt that we had been cheated of an electoral process. Mr. Speaker, sir, we have come here because we want to create a level playing field. Therefore, this is why I say that the greater good will always exceed the lesser evil. Mr. Speaker, sir, there are many good things in this constitution which I do not want to belabor because many of my colleagues have spoken about, particularly, Mr. Speaker, in the development of more resources to the counties. I'm happy that there will be, for the first time, a higher amount, 35%, going to the counties. And therefore, Mr. Speaker, sir, this will spur more economic growth. There'll be more hospitals, more labor wards for our mothers, maternal health care. Mr. Speaker, sir, our children will get more access to education and many more things that we know that come from the good of devolution. Secondly, Mr. Speaker, sir, another good benefit that this bill that brings is the fact that, Mr. Speaker, sir, for the very first time, we are going to devolve these resources right to the tiniest unit, and that is the Ward Development Fund. I think it is a very good thing, Mr. Speaker, sir, that we are able to give resources to the very politicians who are at the grassroots, who are with the people daily. And therefore, when our county members of assembly will be getting this money, Mr. Speaker, sir, I think that there will even be lesser members coming to this August House. Many people will want to be there in the counties. However, Mr. Speaker, sir, as I speak this, there is an elephant in the room in this amendment. And it will not be good that I should speak only of the good without mentioning these clear areas that I feel as an elected member, particularly coming from Kisii County, I must mention these gray areas. The biggest gray area, Mr. Speaker, sir, is the fact that 19 constituencies who deserved to be given another constituency were omitted and left. And amongst these, Mr. Speaker, sir, was Bobasi constituency, One of the constituencies, Mr. Speaker, sir, I was elected to represent as the Kisii County Member of Parliament. Mr. Speaker, sir, this constituency meets the criteria. If it is based on population, it meets that criteria. Mr. Speaker, sir, if it is the question of wards, this constituency has 8 wards. Honorable Biri, the Member of Parliament for Bobasi, will tell you, Mr. Speaker, sir, he has 200 schools to award bursaries to develop on CDF. Yet we know that there are some constituencies in this August House which have only 24 secondary schools or schools. It is a pity, Mr. Speaker, sir, that Bobasi constituency was left. And I understand, Mr. Speaker, sir, from the grapevine that this constituency indeed was there in the schedule, but unfortunately in the midst of midnight, I don't know, Mr. Speaker, sir, which demon or devil sneaked in and they deleted the constituency from the schedule. Mr. Speaker, sir, the next thing that I would like to speak to that is a gray area. This is Article 89 of the constituency, of the Constitution. Mr. Speaker, sir, I believe that Article 89, 2, and 3 need to be relooked at. And I think, Mr. Speaker, sir, when we speak about a constitutional moment, we must be alive to the things that we need to look at so that in future we are able to leave a good legacy and people can remember us as legislators who were keen in looking at these issues. I agree, Mr. Speaker, sir, that we needed perhaps to have consulted IBC on developing this schedule for the constituencies so that, Mr. Speaker, sir, we do not seem like on the one hand we are breaking the current constitution that we want to amend, and on the other hand, we think we are making another right. Secondly, Mr. Speaker, sir, the doctrine of separation of powers. Mr. Speaker, sir, when this doctrine was decided that we should have a separation between the legislature, the executive, and the judiciary, it was to create unfettered discretion and independence of these 3 arms of government. Mr. Speaker, sir, I don't think it would be right to create an executive ombudsman even if that ombudsman is going to be appointed by the Senate, because we will be interfering with the judiciary in the execution of duties. It will be very sad, Mr. Speaker, sir, for example, if in this parliament, after we have made our decisions, then we find that we have now another ombudsman who can overrule our decisions. The doctrine of separation of powers, Mr. Speaker, sir, is a very powerful doctrine to carry the issues of democracy to another higher level. And therefore, Mr. Speaker, sir, I feel that this is a gray area that needs to be looked at. Let us not kill the independence of the judiciary. Mr. Speaker, sir, we never know. Today we have a very good president, Honorable Uhuru Muigai Kenyatta. Tomorrow we can get a rogue president, Mr. Speaker, sir, and we will be tying our hands by not having the doctrine of separation of powers and its independence. Mr. Speaker, sir, the last one I want to point out is the issue of the 47 women reps. Mr. Speaker, sir, it is really indeed sad that we are removing elected women reps from this house, which is a house that deals with the budget, a money bill, the house that deals with the appointment of ministers, appointment of ambassadors, and taking them to the lower house, the Senate. Mr. Speaker, sir, I think it would have been good if the women reps had been left in this house and a way would have been found on creating the dealing with the gender parity issue. For this reason, Mr. Speaker, sir, please, can I get your protection from this side? Mr. Speaker, sir, I said I'm pointing out the gray areas, and as a legislator, it would be very sad if I do not point out the gray areas in this bill. So finally, Mr. Speaker, sir, I want finally to come to the end of this and to say, Mr. Speaker, sir, that the very 2 principles, Honorable Raila Amolo Odinga and the President, Honorable Uhuru Muigai Kenyatta, decided to put down their differences because they wanted to look at the greater good. The greater good will always override the less. So in this amendment, we have 75% that is good. And that, Mr. Speaker, sir, is the reason why we must support this bill. The 25 are grey areas which I believe can be dealt with even before we pass this bill in this House. Mr. Speaker, sir, I beg to support.
Next is Honorable Shamala.
Thank you, Mr. Speaker, sir. I rise to support the Constitutional Amendment Bill of 2020. Honorable Speaker, in the year 2017, our country, more so the Jubilee Party supporters, was stunned when the Supreme Court annulled the presidential election. Kenya would become the fourth country in the entire world to do so, annulling a presidential election after Austria, the Maldives, and Ukraine, and the first in Africa. The country would have to return to a second election cycle, and it would eventually cost the economy of this country 1.7 trillion shillings. After the second election, the Supreme Court would uphold the victory of His Excellency President Uhuru Kenyatta on November 20th, 2017. However, the opposition rejected the judgment, stating that they did not recognize the new government. Immediately thereafter, violence erupted in various places countrywide that was protracted, and there seemed to be no end in sight. Fast forward to March 9, 2018, the country sighed a sense of relief when they saw His Excellency Uhuru Kenyatta and the Right Honourable Raila Odinga in what would come to be known as the historical handshake at the foot of Harambee House. It would culminate to the BBI process and the Constitution of the Kenya Amendment Bill of 2020. The bill expresses the dreams and aspirations of the people of Kenya and where they want to go. They said they had witnessed violence in the advent of multi-party elections and since multi-party elections. Out of 6 elections, only 2 have had peaceful transitions since 1992. In this bill, the people of Kenya have told us that they want regional integration and cohesion. The Constitution of Kenya Amendment Bill 2020 will assure and give assurances that our nation will embrace the goals for African unity with eventual prosperity and stability for all. The people of Kenya have told us that they want equitable opportunities for all Kenyans, which is provided under Clause 11A of the bill. It comes with responsibilities, the BBI bill, on our part as citizens. Amongst these responsibilities are to promote and protect the well-being of the family, including respect for parents and elders, as envisaged under Clause 18A of the Constitutional Amendment Bill. Indeed, the iconic American evangelist Billy Graham said, and I quote, "A child who is allowed to be disrespectful to parents will not have true respect for anyone, and I hasten to add, for anything." The 4th commandment of the Holy Bible tells us to honor our fathers and mothers so that our days may be long upon the land which the Lord Almighty has given to us. This is the only commandment that comes with a rider, a condition, and a promise. And when I look at this country and see the abuse of elders, I think it's probably one of the best clauses in this amendment bill, respect for parents and the elderly. I hasten to add, as a nation, if we abide by this decree, then we shall be blessed long upon our land, beloved Kenya. According to Kenyans, in order to resolve the cyclical election violence, they said they wanted a structure of governance that was consociational in nature, because the winner-take-it-all political system should not and could not fit in the consciousness of Kenyans. Lest we forget, in March 2008, the National Assembly of Kenya passed the National and Reconciliation Accord Act that amended the Constitution, introducing the position of Prime Minister and 2 Deputy Prime Ministers. Honourable Speaker, Article 257 of the Constitution of Kenya 2010 on the amendment of the Constitution by popular initiative recognizes the sovereignty of the people of Kenya and their power to make amendments to the Constitution. The sovereignty of the people is not exercised on specific articles of the Constitution, but the entire Constitution, including the delimitation of the constituency boundaries. Honourable Speaker, the Constitution is the supreme law of a country. In contrast to ordinary legislation, a constitution embodies the fundamental choices made by a country and its people that establish the basis for political and social life. Mr. Speaker, however, while intended to be both a foundational and enduring, constitutions are not intended to be immutable. If they are to endure, they must be able to respond to changing needs and circumstances. Mr. Speaker, the motivation for changing the written text of a constitution differ. Some amendments are made for public interest, like the bill before this House, for example. They can be made to adjust the Constitution to the environment in which the political systems operate, including economies, technologies, international relations, etc. Mr. Speaker, constitutions have to be responsive to social change and to changes over time in social morals and values. Mr. Speaker, it is true that we have inherited a very robust constitution, but no constitution can provide for all eventualities. No document can be such that it needs no change. At the same time, Mr. Speaker, a constitution is not frozen and it is not an unalterable document. It is a document made by human beings and may need revisions, changes, and re-examination. It is true that the Constitution reflects the dreams and aspirations of a society. It must also be kept in mind that the Constitution is a framework for the democratic governance of society. In this sense, it is an instrument that societies create for themselves and amend for themselves. And with those remarks, I also want to thank the Committee on Justice and Legal Affairs, the Joint Committee from the Senate, for the work they did in the report that was prepared. And with those remarks, Mr. Speaker, sir, I do support.
Honourable Member for Kandara.
See?
And I must thank the member who's just spoken. He was very precise and saved some minutes.
Thank you, Mr. Speaker.
And your time is over. So take your seat, Honourable Alice Wahome. Take your seat. Now, the implication of that, Honourable Wahome, is that under any circumstances, you will be the first to speak when the next session starts. That is the essence of that, and you should be very thankful. Take your seat. And honourable members, just to also save the members who have really sat through the afternoon, under normal circumstances, the system would be cleared. But if you members leave your cards, we will come and proceed from where we had reached. That will save you the agony of having to rush out of the door and come back again and put your cards to queue. So the members it will proceed as is now. So honourable members, please leave your cards, those members who wants to remain after this. Other members? So honourable members, time being 6:30 p.m., this House stands adjourned until today, Tuesday, 4th May 2021 at 7 p.m.
functions sought to be granted to the judiciary with regard to the disciplining of judges. According to the committee, in the event the bill is assented to without submission to a referendum, the cited provisions would be unconstitutional. I have a note that paragraph 377 of the report qualifies the findings of the committee by acknowledging that an unconstitutional amendment becomes constitutional if it is approved by the people in a referendum. Additionally, honourable members, at paragraph 506 of the report, the committee notes that there are provisions in the bill that touch on some of the matters provided for under Article 255, Clause 1 of the Constitution. Consequently, pursuant to Articles 255, Clauses 3 and 257, Clause 10 of the Constitution, the bill is one for which a referendum is required. Members will note that Clause 5 of the bill seeks to amend Article 31 of the Constitution, which provides for the right to privacy. Any amendment proposed to a provision of the Constitution contained in the Bill of Rights is protected under the matters listed in Article 255, Clause 1 of the Constitution, and must be submitted to the people for approval in a referendum. By this argument, therefore, the question of unconstitutionality of the provisions becomes moot, or at the very least premature, as the bill must be submitted to the people in a referendum. Any attempt by the Speaker to make a preliminary finding on the constitutionality of the provisions would be premature, speculative, and ultimately an exercise in futility. It would be tantamount to putting the cart before the horse. In any event, honourable members, Article 165, Clause 3, Paragraph D of the Constitution mandates the High Court to hear any questions on the interpretation of the Constitution and settle any contestations with finality. Indeed, I'm informed that currently the High Court has 8 consolidated constitutional petitions challenging the constitutionality of the entire BBI process and had issued an order precluding the President from assenting to the bill if passed by Parliament until the determination of the petitions. Petitions are listed below. Honourable members, the third issue, with regard to whether and to what extent the bill may be amended and the value and place of public participation in the consideration of a bill to amend the Constitution by popular initiative. The committee notes in paragraphs 364 and 65 of its report that the role of Parliament in